discussed an HR and some other HR issues with an employee. Call to order. Mr. Nease.
Mr. Altieri.
Here.
Thank you. Mr. Sanfrancesco.
Here.
Ms. Chanlis. Ms. Grasso.
Here.
Mr. Russo. Your engineer, solicitor, and manager are here.
All right, let's all stand, have a moment of silence and stand for pledge allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. Agenda number 5, agenda 5.1, consider approving the agenda.
So moved.
First by Supervisor Grasso, second by Supervisor Chanlis. Is there any board discussion? All in favor? Opposed? Motion passes. Agenda 6, public comment for agenda items only. Any public comment for agenda items, please say your name, township of residence, and agenda item number. Come up to the podium. Yeah, come up for the agenda item only. If you have public comment for anything else, that's the end of the agenda. We will come to that at the end of the meeting. Yes, if you have some public hearing, you'll grant it something in the public hearing. Yes. Yep. Correct, Mr. Nease?
Yeah.
Yep.
Yes, any public comment related to the hearing we'll take at that time.
Okay. Anything else? No public comment. 7.1, consider approving the minutes from the June 8th, 2026 meeting.
Second.
First by Supervisor Chandler, second by Supervisor Russo. Any board discussion? All in favor, say aye.
Aye.
Nay? Motion passes. 8, reports. Reports from Chief Lunn. Any additions to your report?
Nothing to add.
Thank you, Chief. Chief Young, any additions to your report? Thanks, Chief. Mr. Sharretts, anything to add from Public Works?
Mr. Sharretts is on vacation this week. and I'll take
Well-deserved
any
vacation for
Yes.
Dr. Sharretts. I love it. Codes Department, Mr. Reczek.
Nothing to add.
Thanks, Andy.
bet.
Steve, Finance Department.
The only thing that I would tell you is that we continue to have very good collections on our real estate taxes, which is what I would expect. Things are going well there, and we are continuing to make good headway with the audits.
Thanks, Steve. Arlene Caruso, the library. I think Arlene's here, but always a good job there. The report's great. Township Engineer, Eric.
I'll take any questions on the agenda, but generally, Rear Park project is going to be wrapping up in the next week or two. And good news, with all this rain we've had, all the vegetation is held and everything is doing really well. So, which is good to hear when you just were realigning a stream. So,
Thanks, Eric. And the Township Manager, Steve Nease, 8.8.
Yeah, if you'll recall, at the last meeting, you passed a resolution saying that we were going to have a burn ban, or not a resolution, but you agreed with the fire marshal that we would have a burn ban. The fire marshal and I have talked. Based on all the rain that we've had, we feel that there's no reason to continue that burn ban at this time. So we would not be recommending continuing the burn ban. Burn ban. Say that really fast.
Thank you, Mr. Nease. Agenda item number 9.1, bills. Consider approving the bills on check register A dated June 22nd, 2026, totaling $172,963.19.
Second.
First by Supervisor Chanlis, second by Supervisor Grasso. Is there any board discussion? All those in favor, please say aye.
Aye.
Opposed? It carries. 10.1, developer release. Consider approving letter of credit reduction number 3 in the amount of $73,843.05 to Thomas Pierre relative to the construction at 3111 Sawmill Road, leaving a remainder balance of $468,652.95. First by Supervisor Russo, second by Supervisor Chandler. Any board discussion? All in favor, please say aye.
Aye.
Opposed? Motion passes. 10.2, considering approval of the final $358,497,000 bond escrow release payment to Marple Newtown School District relative to the construction of the Culbertson Elementary expansion, leaving remaining balance of $0. First by Supervisor Chandler, second by Supervisor Russo. Any board discussion? All in favor, say saying aye.
Aye.
Opposed? Motion passes.
Just a quick question on that. Now that it's down to 0, everything is signed off and done with that whole project. Any concerns from?
I don't believe so. Giovanna?
Yeah,
Uh,
everything is completed for that portion of the project. The only open project we have right now with the school district is the ball fields in the back. So we're working on getting that one closed out, but all the other Culbertson related projects and school related projects have been closed out.
Thank you.
That a neighborly concern.
Aye.
11.1, consider acknowledging the resignation of Rich Johnson from the Finance Committee.
So moved.
Grudgingly second.
Yeah.
Okay. First by Supervisor Grasso, second by Supervisor Chandless. Any board discussion?
I take it we're gonna look to replace
That would
that.
be a direction that you could give me, and we would start doing that. If you want us to put it out that we're looking for that, we will advertise on our website and a few other ways that we would advertise that don't cost anything first and see what we get, but it's up to the board.
Yes.
Thanks for Rick for his service.
Yeah. I will say that he has
Second.
volunteered to continue to help us with finances. He just didn't want to be on the finance committee.
We saw
He said he wants to go somewhere else, yeah.
Yeah.
He'll volunteer on it, great.
Yep.
All in favor, please say aye. Opposed?
Can we make a motion to just say yes, advertise for
You
it?
can just give me
Oh.
Skip
direction.
direction.
Oh,
Just
okay,
say,
great.
go
Yeah.
do it, and I will
Yes,
go
good.
do it. Well,
Yep.
I'll be honest with you, I'll direct other people to go do it. So-
Okay, thank you, Steve.
Motion passes unanimously. 11.2, consider the purchase of the photo ID system that will be shared between all departments within the township, including police department, at an amount of does not exceed what's that, $55,000? $5,500. I was thinking, didn't need another zero there, Steve.
You don't need
55,
another.
no, I know. No motion.
So, second.
Supervisor Chandless and Supervisor Grasso. Any board discussion? All in favor, say aye.
Aye.
Opposed? Motion passes. 11.3, consider authorizing the Public Works Director to coordinate the annual salt bid, including advertising on behalf of the 11 Delaware County municipalities. First by Supervisor Rosso, seconded by Supervisor Chandless. Any board discussion?
This is something we did last year too, right?
Yeah, we've been doing it
Yeah.
probably, maybe, no, it hasn't been the whole time I've
Long
been here,
time.
but pretty close. But
And
George
get
has
the best
taken the
pricing
lead.
with the townships, right?
Yeah,
Yeah.
and so by going with the 11 municipalities together, I think out of the last 10 years, 9 of those, or at least 8 of those, we've actually done better than the state contracts. And so that's been the advantage.
Thanks.
All in favor, say aye.
Aye.
Opposed? Motion passes. 11.4, consider authorizing Newtown Township to advertise, request bids, quotes for line painting projects which utilize county aids funds. First by Supervisor Chandler, second by Supervisor Russo. Any board discussion?
I just want to
Sure.
kind of clarify, because it says bids and or quotes. Because it's liquid fuels dollars that the county gives us, the state actually normally requires you to do a bid process. However, the amount of money that we're going to spend is less than the bid threshold. So we're trying to get clarification there. That's why it's written the way it is. So if we have to go out to bids, we will go out to bid. If we don't have to, we're going to just do quotes.
Thank you, Mr. Nease. 11.5, consider
I
authorizing.
don't know that you did the vote.
Okay, do that. All in favor?
Aye.
Opposed? Motion passes.
Thank you.
11.5, consider authorizing the Newtown Square Historical Society to utilize salvage wood segments from the Bartram Covered Bridge Timber Truss Repair Project for fundraising purposes. Any funds raised dedicated to the Bartram Bridge Bridge siding replacement project and potential landscape beautification work at the site. Timbers deemed to have particular historic value would not be made available for this purpose. The action is subject to concurrency by the Board of Supervisors of Willistown Township. Motion made by Supervisor Russo, seconded by Supervisor Chanlis. Any board discussion? None? Those say aye.
Aye.
Opposed? Motion passes. Number 12, public hearing. 12.1.
Supervisor Sanfrancesco, before you get there, can I just interject something real quick?
Sure.
For the advertisement for the finance position, can we just put a parameter that it'd be 2 weeks from Wednesday? So all interested parties should give us information by, I would say, July 8th. So that'll give us a few days. Or actually, let's do 2 weeks from tomorrow. It'll give us a few days to interview those individuals and then be able to have a recommendation for the July 13th meeting.
Sounds good.
If everybody else is in agreement with that.
Sure. Yep.
Thank you.
I just have a quick question too. What if the Board of Supervisors at Willistown Township doesn't authorize the Historical Society?
Yeah,
Don't do
so
it.
if
Then
they
we don't do
don't,
it.
then we wouldn't be able to move forward with that because it's a joint
That's-
bridge. It would take both actions to do it.
Thank you.
12.1, it's a public hearing. Conditional use application, 2224 Boot Road. You guys come from Boot
Vince, you're
Road,
up.
come up to the,
You're up. Uh, Just for everybody who's in attendance, just so everybody understands what's being done tonight, you have two things that are happening this evening. One is a conditional use. The conditional use is focused on the size of the frontage of the two lots. And then the next part of it's just a land development piece. So this first part is the hearing. You'll probably not hear a repeat of everything for the land development side because you're having both happen at the same time tonight. But the first section here that we're getting started is the actual hearing. And so you will have an opportunity to make public comment once the applicant has presented their case and have any other say that way as the board so chooses. Okay. Tom, do you need anything? You're all good? Okay, great. Thank you. Yeah. Yeah, you'll just do the use part. You won't have to do the land development piece. Although my guess is most of it's going to overlap. And so you'll just go ahead and take care until they say the use part's done.
giving you a break tonight, Tom. You like that, huh? Giving you a break tonight. Yeah.
Oh. This application is Township Manager succinctly wrapped up is two parts. One is the conditional use application, which involves a hearing, and the other one's a meeting. The property in question is the property that is right next to the parcel that's currently being built for a dwelling. I think that is owned by Rock Hill Real Estate, 7 or 8 LP. Again, it's a Mr. DeStanislaw's dwelling that's under construction. And right next to it is the proposed parcel number 2. And then the westernmost, the second lot or first lot is lot number 1, which is the westernmost portion of this parcel. This parcel is basically comprised of 3.36 gross acres. It has 3.17 net acres. Lot number 1, which is the westernmost parcel, has got a net of 71,512 square feet. And it's got a gross square footage of 75,471. Lot number 2, which is again the eastern lot, it's got 66,764 square feet, and it has that's the net, and the gross is 70,746 gross square feet. It complies with everything except for the frontage requirement, and the subdivision is filed under section 172-29.b parentheses 1 b and little b, which basically allows the Board of Supervisors the discretion under a conditional use application to reduce the frontage from the 175 required to a maximum low or no lower than 150 feet provided. That's the base amount. And the other thing that's required under the conditional use is that the lots themselves have the minimum 60,000 square feet area requirement. And the ordinance points to a number of factors that the board can look at, including lot configuration. And this is an irregularly shaped lot, and it makes it impossible to put out the 175 frontage requirement. What we're seeking is 158 feet per lot, which is not a major deviation from the required frontage. Again, everything else about the lots are basically in compliance. And our engineer, Jake Tackett, will be testifying this evening regarding the details of that. But his main testimony in this hearing is going to be that the reduction of the frontage is not inconsistent with what it lies, in this area. There are a number of lots that are under 175, and frankly, 175 is probably a very, very high frontage requirement amongst many of the municipalities, including and in this area. But that's not the issue. The issue is whether we have an entitlement to a reduced frontage, and secondly, whether this reduced frontage in any way adversely impacts the R1 district in the immediate vicinity. It's our position that it does not, because of the evolution of this area and the existence of other lots in a similar condition, and also the fact that we're asking for a slight deviation from the frontage under a conditional use, which assumes that you can go down to a 150 foot frontage without, adverse impact to some degree. And we're, like I said, 158. So we're submitting to this board that it is appropriate to grant the conditional use application. This is not a variance. We don't have to prove the hardship as within the context of a variance application, which is very strenuous. It's in this particular case, it's just an undue difficulty or hardship that we're encountering. And this provision has been placed in the ordinance to facilitate subdivisions where the deviation is not that significant. If we were coming in for a deviation on lot size, yes, that would be an issue. But I guess the proof of the pudding is that Mr. DeStanislaw is building his house right next to lot number 2, which is the eastern to the right. And if there was going to be any adverse impact, he wouldn't be doing that. So in any event, I would like to start out with our engineer and go through this testimony quickly.
Before you do that, I need to ask the audience, anybody wants to be a party status?
So in a conditional use hearing, one of the options that folks have is to be bring on party status, which would give you an opportunity to ask questions of the witness. It would give you an opportunity to appeal a decision of the board, is my understanding. And so if you wish to have a party status, we would need to know that prior to testimony being given so that you have an opportunity to ask direct questions. There will be an opportunity for anyone to give public comment at the end, towards the end of the hearing, so that they can hear what the board can hear what you want to say about it. But if you believe you're being adversely affected and you receive notice of this hearing, then you could potentially be a party protestant. And if you wanted to do that, you could, or party of status, you could feel free to let us know now so we can put that on the record as part of the hearing. Does anybody wishing to be a party, have party status? Can you please, can I get you to stand, come up and give your name so the court reporter can record that and so everybody knows?
If it may please the board, I'd reserve the right to ask some questions on party status.
That's okay. Okay. Okay.
I'm sorry, what is that address again?
And the name is Joe McDonald. MC and capital D-O-N, just like the burger.
Anyone else?
Mr.
Good. Good question.
Yeah, I do. Mr. McDonald, where is 45 Boot Road located on this property?
So if you go across the street from the lots that go, I'm on the right-hand side of Boot Road. So the 3 properties that go along the right, all of them in excess of 400 feet footage. I'm the 3rd one on the right.
Did you receive a letter?
I'm sorry?
Did you receive a letter?
No.
400, yours is the last lot
I'm
on the right as you're heading towards Goshen Road.
No.
No.
If you leave Westchester Pike and enter Boot Road, there's 3 properties that yeah, I'm the 3rd one.
So we see the person at the podium speaking. Thank you.
Yeah, I'm just trying to remember the addresses. I think the 3 addresses that you enter when you're at Boot Road is 41, then 43, then 45. They're the 3 on the right. I'm 45.
And how far, where does 42 start? Did you say 42 is the first one on the
No,
right?
the first one is 41, then
41.
43, then 45.
43 and 45. And how far is that from these two proposed lots?
I'd say like a 9 iron.
A 9 iron. Depends how good your 9 iron is.
Yes. No,
You know what I mean?
it's a very short distance, sir. I'm not trying to be funny. I'm just, it's
Less than a half mile.
less than a
correct?
half
Less
mile,
than
quarter
half
mile.
Quarter mile.
Quarter mile.
Yeah.
We think it's about 1,000.
1,000 feet. There you go.
Okay.
1,000 feet from
All right,
that.
so it's not an iron.
There you go.
I'm going to object to the standing for this individual, but and I do have some law on the subject matter that I can hand up to the solicitor.
Here, I'll.
Good.
And just for clarification on my end, we're saying, Mr. McDonald, you said you're 45 Boot Road
Yes.
and we're saying it's 1,000 feet from the subject property,
I
roughly,
said-
Stephen?
Yeah.
Yeah, the engineer's refining the amount right now. He's,
Yeah, the house across the street, 41 Boot Road has a 460-foot frontage, and the next property has a 360-foot frontage.
Hold on real quick, with just regards
And I'm
to,
sorry.
with regards to just granting a party status. Did we rule on that yet?
we're making a determination right now.
Okay,
If it may please.
Do you-
the board, the simple argument is that standing in these type of proceedings for party status has been seriously, defined by the Supreme Court and the Commonwealth Court. And if it's not an adjacent or an abutting or an adjacent piece of property, then you have to be directly affected pretty well directly affected in the immediate neighborhood. And 1,000 feet is not an immediate neighborhood.
The engineer has just revised the number to be 990 feet.
yeah, my opinion is I have to agree with Mr. Mancini on this one. I would vote to deny party status.
So, board okay with that?
I guess the question I ask is, as you enter Boot Road, it's immediately part of the neighborhood, and I am in this
Understand.
area in question. So I don't know what you mean by not directly part of the neighborhood.
With the 990. Ask the board if it was denied party status.
Is that a motion, Mr. Supervisor?
To deny
Are-
party status.
Leonard, are you making the motion?
Yeah, I would make the motion. I'm fine with that.
Can I just ask what we've done in similar cases? I mean, have we looked at any cases that are similar where someone's been as close as this and, sorry, I'm just asking what we've done in similar cases.
So I think for clarification, because we have a motion, is there a second, and then we can have discussion?
I'll second.
Okay, so to answer your question, I believe we've used in the past our zoning, our zoning size that for notification, typically for something like this, which is 600 feet.
So if you deny, and just to refresh my recollection, if you deny party status, they're still able to make public comment. It's just a matter of status.
Yeah, he can't cross-examine the witnesses. He can't present his own case and testimony, but he still has the opportunity to provide public comment.
First and a second.
I guess I have a question. What is your concern with the property? Of a house?
I have a house on my property, yes.
I'm sorry, someone have their microphone on because he can't really, whoever's talking isn't clear.
This is Michael Russo. I said, my concern is they're subdividing this property, put, I assume, 2 houses at some point. And you have a house on your property, so I guess what is your concern that you're opposed to this application?
So, I mean, I, a couple of thoughts. Well, I've read the letter, and in terms of the waivers that were being requested, I have just gone through the letter. I'm not an expert in this area, but I have absolutely some questions regarding the waivers that were requested. I can go through them now.
Well, why don't we let the engineer
Sure.
and the attorney present their case?
Absolutely.
They can explain the waivers, and maybe that'll answer the majority of your questions.
And with regards to the motion on the floor, I think we should take a vote on that before we let any discussion go further.
We have a first and a second. Had board discussion. All in favor saying aye?
Aye.
Nay?
Any opposed?
Motion carries 5-0.
Mr. Mancini, can you address the waivers with your engineer?
Certainly.
Like you typically do?
So what we're gonna
Maybe
do,
this'll-
we need to swear in the engineer
Yeah,
first.
Yeah, but let me.
Wait,
Prior
prior to
I
that?
have somebody else who,
So your party status?
I have no,
Yep, no.
You have to come up to.
Seeing as how
What,
Joe,
I need your name,
David
address.
Lisinski, 43 Boot Road.
Okay, did you receive a letter?
I don't think I did receive a letter. I didn't see it. David Lasensky. Lasensky. Okay. 43 Boot Road.
This isn't for discussion right now. This is just to determine party
Yeah.
status. So
Yes.
if he's denied and you didn't get a letter also, and you're further from the property,
No, I'm closer.
you're closer. So
I'm
what's,
400 feet closer.
what's his engineer? Same?
Just about 600 feet.
Just about 600.
I still don't understand. If you're opposed to this and you're gonna appeal this decision, that's why you're party protestant. If you just have questions about the project at this particular location, that's a whole different thing. Are you guys planning on appealing are you planning on challenging the ruling?
Well,
And
it's
how
not
come
just,
they
it's
don't
not
have
just
enough-
that, right? It's, I get what you're saying, Supervisor Russo, but it's not just that. If they are within the geographic boundary to get a notice for conditional use, which has historically been our kind of guiding post, they would have the opportunity if they wanted to cross-examine and present their own testimony or their own experts as well. So, appealing it is just one piece of that puzzle, but what you're getting at is correct. Anyone has the ability to ask questions and provide public comment at the end of the applicant's case in chief. But for purposes of getting party status, it is not just their ability to go directly up to the Court of Common Pleas on an appeal to challenge any determination made by the Board of Supervisors. It would also allow them that opportunity to present their own evidence and cross-examine witnesses.
I'm just trying to get to the gist. I'm just trying to get to the gist of the issue. And I don't, if you're gonna put in two houses on these properties, I think there's, at least the last gentleman had concerns about the waivers. So I'm not sure if you have concern about the waivers or you just don't want anything on that property. I'm just trying to get to the bottom of this because you really don't have standing because you're not 250 feet away from this property. You didn't get a letter. So,
Yeah.
well, I understand that, Kathy, but he doesn't have standing anyway. He's not 250 feet from the property.
I thought it was
600.
600.
600, all right.
Because the same property owner owns this.
So
Yeah.
he's 600, Eric?
I would set it on just below 600.
Yes.
So are you asking for party status?
Yes.
Yes, yes.
I
Since
could-
he's,
and
since he's below 600, do you have, Mr. Mancini?
my position is basically whether it's 600 or 900, you're still not affected by something like this. You're nowhere near the property. 600 feet is 2 football fields. That's
Mr.
that's
Mancini,
number one. And number two, the waivers have nothing to do with this particular application, the conditional use. The waivers are an SLDO matter, which is part of the subdivision and land development application, which is reviewed by basically the board and the township engineer for compliance and whatever, and whether the waivers requested are reasonable and necessary from a practical development standpoint. So,
Mr. Mancini, did any individuals reach out to you prior to tonight
No.
about this project? Did
No.
anybody call the engineer?
I'm not aware that did they?
Did anybody call the owner?
Anybody? I've not.
Thank you.
Derek, did anybody call?
So
Thank you.
I have, if I can, just for the
Okay.
board's edification and for the edification of the public. I have before you the list of who we notified. We notified 41, 30, 0, and then 30 properties on Boot Road, the 16 Boot Road, and the rest of them were Westchester Pike properties. And it's actually, I apologize, it's actually 500 feet, not 600 feet.
So if you did receive a letter, we're gonna go with no party protestant if they're under 500 feet. Board okay with that? 500, since it is 500 for the notices. Again, they can give public comment at the end, they can do it, they can do that, but again, for a party protestant, that needs to be consistent with what we've been doing.
I'd like to make a continuing objection to a fixed 500 feet.
Understood.
I'm just gonna say, I think because there was some confusion that I don't have an issue with him being a party protestant. He can ask questions if he has any. And I think if everything lines up and is fine, we shouldn't have any issue. Moving forward, I think we just need collectively to know it's 500 feet.
Okay.
Well, let me ask you this question, Steve. The letters that are mailed out are done via the county GIS, which sets the radii from the subject property to 500 feet to be in conformity to our ordinance. Is that correct?
That's correct.
And so if that list doesn't have those properties on there, then the county's own GIS is saying that they're not within the 500 feet.
That's correct.
Okay. Is there a motion on David's party status?
There's not.
I make a motion to deny.
Second.
Any discussion?
Any discussion?
Well, I mean, I'm unclear on what we've used in the past because we just indicated that it was 600. It was within that boundary. You know, if he's close enough to be affected at 500, isn't he close enough to be affected at 550? Like, I mean, I don't know. I don't see what the issue is. Like, I have a feeling when everything's presented, it'll be resolved anyway. We just haven't heard anything yet.
I don't think that we've set a hard and fast on the geographic distance. It's been whether or not they've received a letter. It's kind of the hard and fast that we've always taken the approach on. And in this instance, again, the county's own GIS is not flagging that property to receive the letter.
We have a second. Any more board discussion? All in favor, say aye.
Aye.
Nay?
No.
3-2 carries. Party protestant is denied. Anyone else? Okay, we need the you sworn in. Tom, it's all you.
You swear to testimony.
I do.
State your name and
Good evening, my name is Jacob Tackler. I work with T&M Associates, the civil engineering consultant for the project. Jacob Tackett, Tackett, with T&M Associates. T&M Associates.
Mr. Tackett, could you please state your profession for this board?
I'm a civil engineer.
And how long, by whom are you employed?
T&M Associates.
You've worked on a number of projects on behalf of T&M Associates for Mr. DeSantis or some of his business entities?
I do.
Okay, now, this particular application tonight is completely different from those items, though, because this is a residential function, not commercial. Or have you also worked on the residential aspect of this one?
I have, yes.
Okay. Could you please tell the board what you had to do?
Typically, my role on these projects is to review properties my client is interested in and develop a site plan that conforms with the municipal ordinances as it relates to site layout, bulk density requirements with the zoning ordinance and stormwater management, typically protecting existing natural features where required, but it is not unlike other land development projects that you would see for commercial or industrial development. This is just on a residential scale.
Okay. Are you familiar with the property?
Yes.
And could you please take a look at Exhibit 1? What is that?
This appears to be a deed.
Is that the deed that I believe Mr. Kirk and the trust conveyed to Rock Hill Real Estate, Roman numeral 22 LLC, I believe. Is that correct?
That is correct.
And did you have occasion to review the legal descriptions, and the past, well, the legal description in that deed?
I have.
For my request, I might add.
I have reviewed it, yes.
And that was basically to determine with accuracy how much acreage was located within the overall parcel of the two lots that had been merged. And that was for the purpose of determining the overall acreage of the parcel per se. Is that correct?
That is correct.
Now, I turn your attention to Exhibit 2A, which is basically the subdivision plan that's on the screen. Now, did you prepare that plan?
I did.
And to your knowledge, is the information located on that plan true and accurate?
It is.
Did you also have occasion to order and rely upon an Alta title survey that I believe is attached as Exhibit 4, if I'm not mistaken?
That is correct.
Okay. And that was based on an actual survey, and it showed some topo features as well. I think shows steep and very steep slopes in the right of way of Boot Road. Is that correct?
That is correct.
Now, you computed, well, you tell me, what is the total gross acreage of the overall tract?
The total gross acreage of the existing tract is approximately 3.17 acres.
I believe that's the net.
Oh, I'm sorry. Is that the net?
Now you can take a look at your own subdivision plan.
Our existing, I apologize. The existing gross is 3.36 acres,
All right. And the net?
3.17 acres.
Now, lot number 1, that's the one on the western side, that is on the left-hand side. That's the bigger lot.
That is correct.
And what is the gross acreage and net acreage of that lot?
The gross acreage of lot 1 is proposed to be 1.733 acres. The net acreage is 1.64 acres.
Now, how does that translate into square footage?
The proposed net lot square footage is 71,512 square feet, give or take.
Okay. Now, the R1 district requires a net of 60,000, correct?
Yes,
So this one is about 11,000 in excess?
that is correct.
Okay, now how about lot number 2, the eastern lot?
The gross acreage is 1.624. The net lot acreage is proposed to be 1.53 acres, which equates to approximately 66,764 square feet.
That's net, right?
Yes,
And what's the gross?
approximately 70,746 square feet.
When you say net, you're netting out the right-of-way of Boot Road
That is correct.
and also any, I think 50% of very steep slopes.
That is correct. None of which,
50% of very steep slopes and basically, I believe it's 25% of steep slopes,
neither of which are present on the property.
except,
For a small man-made stockpile in the rear of the property as a result of other development in the area.
I mean, the very steep slopes, take a look at the,
Are located within the
take a look
right-of-way.
at the, please take a look at the Alta survey map. Okay, now where are the very steep slopes located on that map?
Within the Boot Road right-of-way.
Now, and are there steep slopes in there as well?
Yes,
Now, did you net out those steep slopes that is deducted with the
Yes.
right of way? All right, so your statement that the net is basically net of those steep slopes and very steep slopes that are in the right of way, because you have to, deduct the right of way in any event, correct?
Correct.
Now, both lots have 158 feet frontage. Is that your understanding?
That is correct.
And you're aware of section 172-29B parentheses 1, parentheses A, which sets forth a minimum lot size of 60,000 square feet and a frontage of 175 square feet.
Yes, 175 feet of lot frontage.
Now, that section also has a second paragraph, which is basically 172-29, capital B, parentheses 1B. Love that B. Of the zoning ordinance, which do you agree with me that it authorizes the Board of Supervisors to grant, in connection with a subdivision, up to and not to exceed a conditional use allowing for 150-foot instead of the 175-foot frontage?
It is my understanding that that can be done, yes.
And there's also an additional requirement that the minimum lot size of the subdivision averages or independently of the lots in question all have to be 60,000 square feet or more as to size.
Yes.
And now, in your view, what is more important, to have the size or the frontage?
I believe the lot size is more important, provided the lot frontage is still appropriately developable.
Okay. And as you previously said, both lots 1 and 2 in your subdivision are in excess of 60,000 square feet net, correct?
That is correct.
And in that, in fact, it's lot 1 is 71,512 square feet, and lot number 2 is 66,764 square feet, both net.
You said 71,512, correct?
Yes, I did.
Yes.
Lot 1, 71,512, lot 2, 66,764. Now, and you also indicated that in computing net acreage, you took out the Boot Road right-of-way area,
Yes, I exclude all right-of-way area in those net calculations.
including the very steep slopes and steep slopes in that area.
Yes,
And how were they created? Is that the difference between the paved cartway and the shoulder, which rises, I presume?
yes, I would say that that seems consistent with the topography of the site.
All right. Now, are there any other very steep slopes on this site?
I do not believe there are other very steep slopes on this site.
And naturally occurring steep slopes, how about those? Because I think they're between 15 and 25%, whereas very steep is 25% and up, or above 25%.
Again, no, I do not believe they are present on this property.
All right. Are there any wetlands or floodplains in there?
Not from what we could determine, no.
Any streams or floodways on the property?
No.
Now, in your opinion, with 158 feet of frontage on each lot, is there adequate frontage to address for a residential dwelling? And they're both going to be for a residential development. That's it. An adequate line of sight for coming in and coming out.
Yes, I believe that it can be accommodated.
Is the access with 158 feet of frontage provide you ample opportunity to design an access to the property,
Yes,
a safe one,
yes,
adequate for utilities,
yes,
and adequate for any other issues relating to frontage?
yes.
Are you familiar with the concept of frontage versus width at building line?
Yes,
Are you aware of other municipalities that have R1 that have 50-foot of frontage, but 200 feet of width at the building line requirements?
I couldn't name a municipality offhand, but I know that other municipalities have differing requirements for frontage and lot width at the building setback line,
Okay.
often which are more constricted or restrictive.
Yeah.
Thank you.
Now, in this ordinance that we cited for the reduction, by conditional use, authorizes the board to go down as low as 150 feet, correct?
Yes,
Is that, and would you say that that's a reasonable frontage as well?
yes,
And it's specified by the ordinance itself, okay. Now, the next question is a frontage of 158 feet in keeping with the character of the community and how it's developed?
I would say yes. There are properties along Boot Road that have less than 175 foot of frontage. There are several that have less than 150. So this proposed subdivision is keeping in consistency with the typical character of the community.
Now, you're aware that this property had been the subject of an earlier subdivision back in 1953?
Yes, I am aware.
And these two lots were actually identified as lot 2 and 3 in that subdivision plan?
That is correct.
Could you please turn to Exhibit 3? Here, that is the Hootman subdivision plan of 1953. There you are. What's Exhibit A up there, but in the packet that I have submitted to the board, it's Exhibit 3. Now, could you please identify the two lots which are numbered 2 and 3 on that plan?
Lots 2 and 3 are in the upper left corner of the plan. The furthest upper left parcel is lot 1. So where your cursor is are 2 and 3.
Okay. Now, lot 1 still exists in its form, correct? Somebody owns it and has a house built on there.
That is correct.
What is the frontage on that lot?
It is approximately 145 feet.
Or 150, depending on whether you take it at the right-of-way line or
Correct, or
at
the
the cartway line,
correct.
or the title line. Okay, so that's well below 170, isn't it, or 175, correct?
It is.
All right, and going west on Boot Road, how many more at my directions did you check to see how many more properties had sub 175 foot frontages?
Approximately 7 properties along Boot Road are less than 175.
Okay. And those properties have not had any difficulties getting into their property or out of their property?
Not to my knowledge.
Now, lot number 2, if we can go back to the subdivision plan in question, which is Exhibit 2A, I believe. I'm sorry, just the subdivision plan is 2A, but I don't think it's numbered, it may not be numbered for your exhibit. No, that's the Hootman plan. Right there, that's it. Now, if you go to the right of that plan, that is the lot that is owned by, I believe, Rock Hill Real Estate 4 LP. Again, the principal in interest is Mr. DeStanislao. And that property is being developed currently for a single-family residence for Mr. DeStanislao. Is that correct?
Yes, that's correct.
So he would be right next to lot number 2.
Yes,
And his lot is non-conforming, if I understand. I think it's about 52,000 square feet.
from an acreage perspective, I believe you are correct.
Okay. Um, Now, the 1953 Hubman plan, that had frontages for not only lot number 1 on that plan, but also 2 and 3. Were any of those frontages in compliance with the 175 that exists today?
No,
All right, now, how does the current proposed frontage that we're putting up differing from the frontage that appeared in that 1953 plan?
there are minor changes. Lot 2 in the Hoopman plan, proposed lot 1 is being increased from previously approved 152 of frontage to 158. And then lot 3 in the Hoopman plan is being reduced from 160 to 158. So largely consistent with what was previously in place.
All right, so basically, you're allocating the frontage equally between the 2 lots.
That is correct.
All right. Now, in your opinion, does the 158 frontage reduction from 175 pose any detriment to the public health, safety, and welfare?
No, I don't think so.
Does it pose any danger to traffic on Boot Road?
It does not.
Does it pose any detriment for egress and egress from lot number 1 and 2 in your subdivision?
No,
How about from abutting parcels
no,
to the west and to the east?
no.
All right. And we've again established that to the west is what was lot number 1 in the 1953 Hoopman plan, and to the west is Mr. DeStanislao's or his entity's lot that he's building his home on. Now, in your opinion, would this grant of conditional use overcrowd the land in any way?
No, I don't believe it does.
Will the reduction of frontage be in keeping with the R1 district?
In spirit, yes.
And in your opinion, do the facts of this case warrant the grant of a conditional use for to allow this subdivision to occur?
It does.
I have no further question of this witness, and I would like to move all my exhibits 1 through 4 into evidence.
Okay. Open up for questions. Any board comments or questions from the board?
I just have one quick question. You said it would be in keeping with the R1 district. You said in spirit. What did you mean by that?
Because the lot frontage would be less than 175, it does not comply with every bulk density requirement, but it is consistent with the neighborhood surrounding.
Eric, do you know if when that was updated, was the lot frontage updated recently to have a lot frontage of 175, or has that always been part of the code? Like, has there been any recent updates to that we know of?
I don't believe, I think he's pulling it up right now. I don't think there's been any recent updates to the code. I believe that is the frontage that is established by the ordinance. for some time now, but a lot of these lots do also predate the modern zoning ordinance. in the
But you
town.
said
Okay.
that 8 or 9 houses on Boot Road have less than that, correct?
That is correct. There are several. I counted 7.
What are those addresses?
I do not have those addresses readily available.
Going on to Supervisor Grasso's line of questioning, with regards to the ones that are on Boot Road that are under the lot frontage requirement under the ordinance now, do we know, or Jake, do you, or Mr. Mancini, do you know if any of those properties received relief to be under that lot frontage, or are we surmising that they are all just existing nonconformities in a way?
You know, frankly, I'm not sure because I know that minimum lot acreage and minimum frontage requirement has been in existence at least since 1980 or 85, but I'm not familiar with events before that. But I do know that the waterfront developments, the Springton Point developments that are in Newtown Township, that ordinance did have the ability to average the lots and also reduce the frontage where it was necessary to complete or helpful to complete the subdivision.
I'll just, I recount, so the date, this ordinance section was adopted in 1994.
The current one, yeah, but the preceding, if you look at the plan, you can't find the ordinance because the township doesn't have it. But if you look at the developments for Springton Point, you will see that they permitted lot averaging and reduction of frontage. So I don't know how these came to be.
Other questions from the board?
Yeah, I just have just a few more. The zoning district is what, R2 or R1, did you say?
R1.
And I know Mr. Mancini made the comment, but did you testify as well that the properties are going to continue to be operating as a residential use in the future?
That is correct.
Right. And so the, fear that I think a lot of the residents have on that street is that it's going to be an expansion of the Porsche, Ferrari dealership. That is not occurring, correct? It'll continue to be residential.
I can categorically say no.
And Mr. Mancini, one of the reasons for that is even if they were to operate that way, they would have to go to the zoning hearing board because it's a completely different zoning district. Is that fair?
That's correct.
Okay.
And
Bottom line is it's staying residential.
Yeah.
Perfect.
Jay, can I just ask one last question? Of those 7 to 9 houses that you said have the street frontage that's below the ordinance requirement, are any of them directly adjacent to the subject property?
There is one, the property adjacent to proposed lot 1 has a frontage of less than 175. And the 20 Boot Road property to the east of lot 2 is less than 60,000 square feet.
Thank you.
There's 2 of them are less than 60,000 square feet. Several, yeah.
Any questions from the board?
When do we open it up for public comment?
As soon as we're done, questions from the board?
Nope.
Questions from the public comment for the public who's here tonight? Please state your name, address for the record.
Green light? Yeah. Good evening. My name is Karen McDonald and I'm here with my husband, Joe, and we live at 45 Boot Road. Karen, Karen, and McDonald, like the burgers again, MCD. Irish, not Scottish. All right. Since the details of this meeting were published around 5:30 Friday evening, we've not had much time to prepare. But like so many other Boot Road residents, we've been attending meetings regarding Porsche for years. Sometimes we arrived feeling upset, disappointed, or even angry. Tonight, honest to God, we're just weary. Some time ago, a member of your board reminded his peers that they had a duty to consider not only the requests being made by Porsche, but to also ask themselves how that request would provide something positive for the community's stakeholders. He continued by saying that Boot Road residents had been called to represent the neighborhood too many times, and we deserve some peace. He's no longer among you, and we're here again. I've listened to Robert, the owner of Porsche, speak, not the attorney, Mr. DeSanta, I don't know how to pronounce his last name, Robert D. I've listened to Robert speak about his hopes and plans for Porsche and his other automotive enterprises on several occasions. And I recently watched recorded township videos where he and his representatives spoke passionately about the exceptional nature of their plans for the newest building at the corner of Boot Road and Route 3. And hey, we live in the United States. My husband and I have worked tirelessly for decades to prosper, and we defend everyone's right to the pursuit of their American dream. But now Robert has quite literally turned the corner. Boot Road is not a business. This is a community. We're a small neighborhood of people who know and understand how special this place is. Some of these homes have been inhabited by multiple generations. Others have lived here for decades, raising families, hosting weddings in the backyard, and breathing their last breath here. Like so many others, our home is our greatest financial investment. Its value will be our legacy to our family, as well as a backdrop against uncertain times as we are very nearly approaching retirement. But mostly it's the place where our 3 children and 6 grandchildren gather to make our family memories. Now and in the coming months, our little community is being asked to consider significant changes. Where there once stood a flower store and a pizza shop, there will be new construction. It has also come to light that the owner of what was believed to be a single-family home, 6 Boot Road, blue house on the right before you would come to the Westchester Pike, has actually been using that home as an apartment building for the last 3 decades. The owner plans to come before you next month to ask permission to continue to do so. Robert has purchased every property or lot between number 6 and number 30 Boot Road. One has a house on it, and another holds a foundation that was poured about 6 months ago, and it sits fallow. And now we're being asked to accept changes to a lot without knowing what is to come.
Limitation on public comment.
I beg your pardon.
There's 3-minute limitation.
I'm 1 sentence away.
Well, you're done your 3 minutes.
It would have been nice for you to share that with me before, but thank
For
you.
your comments. Thank you. What's your name and address for the record, please? Name and address for the record.
Joe McDonald at 45 Boot Road.
Great, thank you.
And I just want to get into some of the, I mean, I saw the information posted late last week, and there's a waiver letter that I focused on that I had some questions that I know no one's going to be able to address them, but I'd like to raise them for just awareness.
So Mr. McDonald, that I don't want to take away your 3 minutes, so don't start the clock yet. The waivers will be discussed at the land development phase, which will happen right after the conditional use. All we're talking about right now is the conditional use on what Mr. Mancini has presented to the board. The only thing we're talking about is just granting the lot frontage reduction from the required 175 feet to the requested 158 for the 2 potentially soon to be subdivided parcels. That's it. The waivers would all be part of the land development presentation that Mr. Mancini would do next.
Good. I do think this is relevant to raise because,
Okay.
For example, in looking at the note and looking at this part of the neighborhood, which includes historically designated homes, I think there's keeping with the character of the community, I would refute what was stated earlier, that significantly changes this front end of Boot Road. And in fact, when I looked at the waivers, and I know what you're saying, but the applicant has an argument that the separate reviews will delay the project and create unnecessary burden. But I mean, there's a question about whether there is a project that's in place. And so I raise that because I think it's important to know what the ultimate project is before anything moves forward. Sorry about that echo. But there's a question about what, there's different things that I think the zoning commission, is that me? I won't move. Sorry about that. But relative to the way this is being looked at, I mean, there's a lot of questions about how this property is being subdivided. I mean, no improvements are proposed, but how do we evaluate what is involved with the neighborhood compatibility without knowing all the conditions? There was a questions about slope. They said there's not significant slope. But until we know that, I mean, how do we even address the broad frontage issue? And in fact, related to the frontage issue, it's like there's questions about what the township is being asked to approve. We're creating 2 lots. We're waiving information. I mean, there was one of the waivers, which the preliminary and final approval would be done at the same time. I'm not sure what the urgency is here. Because there's a question about whether the use of this land and the engineering factors are really being addressed. I mean, I think it would be helpful to get more information relative to what's being proposed for this property, what specific slope issues, what frontage issues, and what the makeup of that front end of Boot Road before any decisions are made. So I wanted to make sure that that was clear. And then I have to, say that, I have to question the confidence I have in this property. I don't know what the 20 Boot Road frontage is. There's a variance on the lot size, but someone asked why if we have connected with the owner. We have never met the owner. And in fact, there's and this was mentioned, but that lot, which hasn't been mowed and trash has been blowing around all winter. And now we're supposed to have confidence that what he's going to do in the lot next door is going to be an improvement over that. So I say there's a lot of unfinished work and a lot of questions about the ability to execute this.
3 minutes.
Thank you.
Thank you for your comments.
I want to make a comment. Mr. McDonald, you can call the code enforcement office anytime you want to complain about maintenance. If the grass is high, if there's trash on the lot, and the code enforcement person will go out. And if it is in fact not maintained, we have an ordinance, he will be written up. As are many other properties in town on a weekly basis.
Register that right now. Go out there. It was very hard to
You
see.
can
the sign
call,
that
you can
was
call the
placed.
office tomorrow
I
and
will.
register your complaint.
Very good.
I don't understand why no one has a conversation with this individual.
Because he's non-existent. There's a foundation that
There's
was
a
placed.
form on our website also you can fill out for that information to
I
report that property.
looked at the website. There's no owner.
No, there's a form on our website to report the violations.
Very
If you want to
accurate.
make that too.
Thank you.
Thank you for your comment. Any other public comment? Please state your name and address for the record.
My name
please.
is Scott Shaver. I live at 79 Boot Road. My house doesn't have 175 feet of frontage. I can attest to that. The scariest part of my day is pulling out of my driveway. The second scariest part of my day is pulling on the Westchester Pike. So the 2 of you, I don't know if you live on Boot Road or if you've seen the changes to Boot Road, but since your client's development of the end of Boot Road, I could probably say that accidents have gone up significantly. The speeds on Boot Road have accelerated significantly. So that would be one thing I would attest to. You guys attesting to the character of the neighborhood. I don't think you know anything about the neighborhood personally. Also, your client, is this going to be his primary residence at lot 1? Okay, because as far as I know, he's not a resident of PA. Lives in New Jersey. Okay. Okay. I find it hard to believe. And like I said, it's just every evolution of the development of the land that he owns has made living on Boot Road, in my opinion, more dangerous. And that's why I'm here. I haven't been here for previous meetings, but I think it's kind of nonsense that we're allotted 3 minutes to talk and he's not allotted state whatever it was, just because he's 500 feet away or 600 feet away, or, you know, whatever you want to reduce the footage to. But for whatever reason, it was set at 175, and we're here to change it. And you're saying that there's no significant relevance to changing it to something lower. Well, you're adding a driveway to the end of Boot Road. And I pulled out of my own driveway, pulled out of my neighbor's driveways, and I would say it's one of the most dangerous parts of my day. Probably zero. I'm a shared driveway, and my lot's in the back. Okay.
Vince, can you please pick up the mic? I don't mind you saying it, just pick up the mic.
I think that there's misconception here, and I think, listen, nobody wants anything there. It's obvious. Okay?
I think adding another,
but
adding
again,
another
you
driveway.
can't.
What's that?
Please use the mic. Please use the mic, Vince. Thank you.
If it meets with your approval, I will provide the community a couple of names that they can call, including Mr. DeStanislaw.
Okay.
It is so that someone will be available to respond to questions and
Okay.
react to any conditions that are troubling you.
The
Because
condition that troubles me is adding another driveway onto Boot Road, because that is the most dangerous part about Boot Road. It's pulling out of our driveway.
And well, remember, this is public comment also. We're supposed to be listening.
SHAVER. SHAVER.
And as a board, we will get those contacts and get them out to you.
Okay,
Thank you.
Yep.
Name and address, please, for the record, please.
I did it earlier, but David Lesensky, 43 Boot Road. David Lesensky, Lesensky, 43 Boot Road. There's two issues for me. One is the character of Boot Road. I have 4 acres, Joe has 4 acres, 41 has 4 acres, and Kevin, next to Joe, McDonald has 5 acres. And there's other properties with my frontage is well over 300 feet or better, maybe 400, I'm not sure. But you don't find that in Newtown Square. What you're finding now is multifamily congestion and everything else. And that road itself is unique. And by allowing this to be subdivided into 2 building lots, it takes away from the character of the street itself and may very well set a precedent for the other 6 lots between Nick Mancini's house and Ed Pereira's house. I think DeViton has 6 lots, if I'm not mistaken. All DeViton or National Realty, whatever name they're under. In the valley there, there's 6 residential lots. And my fear is that this sets a precedent that will have these mini houses and the Stark homes and the large acreage lots. I just think the beauty of the road is the land. And I don't want to set a precedent and have the other 6 come in here and have 12 more homes.
Thank you.
Thank you for coming. Anyone else? Want to name and address for the record, please?
Henry Ferentz, 61 Boot Road. Farrand. And I just like to make a comment on how the traffic is on Boot Road. I've been there since 81. And I've seen a lot of changes. Worse is when they put the turn lane off of Westchester Pike. I've seen traffic increase. And I have about, I don't know, 300, maybe 400 feet frontage. And I'm scared pulling out because if people go so fast and there's so much traffic. And it's a shame what the roads become because of over the years. It's changed. I used to take my kids for walks on the road. Now I'm afraid when I mow my lawn along the road because they're going so fast and so many cars. So that's all I got to say. Thank you.
Thank you for your comment. Anyone else for public comment? Name, address for the record, please.
Greg McEwen, McKeon, 81 Boot Road. Just following up on Hank's comments. He's not exaggerating. If you guys know, you know the neighborhood, you know the street. I'm not saying it's all Porsches, but high performance cars come down that street, and I'm telling you, someone's going to get killed. Someone will be killed on that road one day, if they haven't already. We've been there 5 years. Pulling in and out of my driveway, it's dangerous. And to his point, to Hank's point about Route 3 and the turn, there should be a traffic light there. I mean, if you guys ever stood there at 3, 5, 7 o'clock, even at 12:30 in the afternoon, you can't even get out. I think there should be a change there. And the high performance cars on Boot Road, it's like a raceway. That's all I got to say.
Thank you for your comment. Name, address for the record, please.
Ellen Kane, Kane. I'm at 102 Boot. I just wanted to echo.
Boot Road. Make sure you use the microphone, please.
I just wanted to echo how it is a raceway. I am so angry tonight. We have been fighting Porsche for probably a decade. And Robert keeps encroaching and encroaching and encroaching. It's disgusting. How many times have I called Robert and his representatives to complain about the test drives, to complain about the trash, the noise? You get nothing in response. He bought the farmhouse right at the end of Boot Road. People were living there. I kept calling code enforcement to come out because they were using it as their office space. I'll tell you right now, I looked in the windows. You saw cubicles and desks. The poor guy from codes kept going out and couldn't bust you, but you're still using it for commercial purposes. Anytime you come down Boot Road, there's a semicircular drive in front of the farmhouse, packed with Porsche, packed. I have seen, I can't even tell you how many times. I always complain to my husband. I'll be like, damn it, I saw it again. You see mechanics walking from Porsche through the empty lot where supposedly Robert is building his dream home, which has been poured and left vacant for what, 8 months? He's not building anything. He has a mega mansion in Morristown, New Jersey. Okay, let's keep it real. So he is not making this great effort to come live in Newtown Square and finish his home. So now we're going to let him take over 2 more lots and subdivide them. He owns a real estate company, right? Word on the street is it's going to end up being an apartment building. Like, we need more traffic, more cars, more anything on Boot Road. So this Robert has been a freaking nightmare, at least to those of us who are here tonight, because we're constantly fighting to keep him in check. He wants to take over as much as he can, and unfortunately, he's been allowed to go a little bit too far. But I've had enough. It is our neighborhood. This is our community. He can go
Okay,
back to
fine.
New Jersey
Thank you for your
and
comment.
open a dealership there.
Thank you for your
Thank you.
comments. Any other public comment? Okay, seeing none, public comment is closed. Nope, this is just public comment, sorry. This is just public comment. That public comment is now closed. The next steps.
All right, so if the board has any other questions of the applicant, it could ask those now. If not, you could move forward with a vote of whether or not you would accept the, I believe it's considered a conditional use.
Keep the hearing open.
To do that,
Yes.
they can close the hearing, correct?
We close the hearing.
Yeah,
right now,
close
right?
the hearing now.
All right.
I have a question too.
And but if there's any questions, I would keep the hearing.
Kathy,
open.
Yeah,
we're still on the record. Thanks, Tom.
I just had one more question. How many properties on Boot Road have the frontage that's above 300? Yep, sorry. How many properties on Boot Road do you know have the property, frontage that's above 300? Frontage above 300?
Frontage on Boot Road?
Yeah.
If I think the subdivision plan, the Hootman subdivision plan might afford a better idea because that has properties he's bought. And
What you're asking is, they know how many don't, we don't know how many do.
Right.
Correct. Of
Which I guess
all
you
the
could tell how
road,
many-
He wants it, she wants it, you don't have that number.
the Golden stops with lot number 1.
Yeah, Cat, Supervisor.
Vince, can you use that microphone a little bit closer?
Entire Boot Road, how many are,
Can't hear.
That parcel, then he had.
Mr. Mancini, can I get you to move the mic closer, please?
Yeah.
Please, thank you.
I have once submitted a site plan of all of the tax parcel maps, both on Westchester Pike and Boot Road. But Boot Road, to my recollection, is he owns this parcel.
not asking that, she's asking for all the owners on Boot Road, how many have over the,
Oh, the frontage?
correct, the frontage, yes.
There are more than 10. I don't have an exact number, but there are more frontages that are greater than 300 than are less than 175.
And how many houses or properties are from Westchester Pike to Goshen Road on Boot Road?
I don't have an exact count, but somewhere in the 20 to 30 range, I believe.
Any other questions for the board? Before
So,
we close the record.
I used to work at Mom's Bacon Home Pizza, then it became a Casa Pizza when I was in high school. So I'm very familiar with the area. I just had a question. You said to the answer of you do not see that there is any health, safety, and welfare issues there. Can you tell me how you determine that?
It's a vacant lot, so there are no existing conditions to be concerned about. The question that was asked was whether or not the proposed frontage would create any health or safety issues. Typically on lot frontages excess of 100 feet, you have ample sight distance to safely maneuver in and out of the driveway. And so that was the response to that question.
And quick question, we are talking about 2 homes, correct?
That is correct.
2 homes as opposed to 1?
That is correct.
Mr. Mancini, the property to the left of this, going closer to Westchester Pike with the big old farmhouse, does your client own that property?
To the left? No, he does.
We're going to the south.
Oh, south.
Yeah.
Yes, he does. That's where he's building his house, right next.
No, that's to the north. The one with the circular driveway that somebody said something about earlier.
There's a current house on.
There's an old farmhouse there. Is that your client? Or is that somebody else's property?
Yes,
Yeah, I believe it is.
it is.
Okay.
And just, I understand that the residents had received this letter, that were within the 500 feet. But other people that may have concerns only saw this information Friday. So is there a reason why we have to do the preliminary and final together?
That is related to the land development application. not-
Yeah, we're just talking about conditional use.
Okay.
I think everybody's conflating all these different issues, and I think it's confusing and frustrating the residents even more. All we're talking about right now is the conditional use with regards to the lot frontage. All the other points that were brought up, some of them valid, are either related to the subdivision or exclusively in land development. And none of them are related to the conditional use hearing that we're discussing tonight.
Leonard, or Supervisor Altieri, I appreciate that comment, because I feel like I have heard land development is coming next, and I have also been confused about that. So right now,
Yeah.
we're just saying that on the agenda tonight is just simply the subdivision or the conditional use. So I think it would be helpful to let everybody know that that is truly the case.
I want to be clear,
Yeah.
okay? What we're doing now, right at this moment,
Right.
is looking at the conditional use. When we close this hearing and you take action, the next thing on the agenda is the land development piece. So just, I mean, but tonight, right
It's
now,
not,
what you're
but
doing.
it's not land development, the subdivision.
It's subdivision, my apologies.
Okay,
Yeah.
that, okay.
Development.
Yes.
Yeah.
For land
And the
development-
reason for that, so that.
The land development, he's gonna have to meet with these
Supervisor.
residents before we come back, and we're gonna get, you can hear there's 5 people on the board. No one's gonna give him preliminary and final until he meets with the residents and gets his act together and gets that property cleaned up. And at least has a conversation. Whether it goes well or not, we have to have a conversation.
Any other board comment?
Eric, I have a question for you. It says the minimum frontage of at least 175 feet. And then whereas the Board of Supervisor, after a public hearing, finds that the grade of the ground, its terrain and shape is such that it cannot be developed without creating an undue hardship. That was something that you put in your Pannoni letter. The minimum frontage is 175 feet. So I feel like I think that if there are others that will be subdividing, we may be setting more of a precedent. I know that there are some that are under that lot frontage, but are we setting then precedent for any other subdivisions along Boot Road?
I mean, I don't know if that's necessarily a question I could answer. I can tell you the code is at 175 feet, but it has a provision, which is the basis of this hearing, which could reduce down to 160. Is that a precedent? I guess that's a case law on that one. I don't.
Yeah, well,
Can I ask a question?
that we're on public, we're at board.
Talk for 40 seconds of my public speak. Good questions.
We're at board comment, not public comment right now. Thank you. Any other board comment? Okay, next steps. Close the hearing? Close the hearing, Tom? I closed at, let's see here, 8:39.
Hey, I'm sorry. For some reason, I keep getting muted. So if I can just add this, is just, I just want to be very clear again. To the residents that are there, the entire board appreciates everything that you've said, but I think it's extremely important to understand where we are in this process. This is just purely, again, the reduction in the street frontage. The applicant would need to get that relief first before they can move forward to the next hearing, which is going to be the subdivision, which is taking the one lot, making it into two. Then in the next couple of months, they're going to start developing whatever plans they want to start developing. And that's when the land development aspect comes together. I think it's important to flesh out that this is going to be and will remain to be a residential use. It will not be a commercial use because it's not permitted in that zoning district. Multifamily, I'm pretty confident, is not permitted in this zoning district either. So it's going to be single family. And I think it also allows for like nonprofits and other things. But again, you know, what we're talking about here is residential. So, you know, I know it can be confusing where we are, and there's a lot of nomenclature that normal people don't use on a day-to-day basis. But all we're talking about right now, and I know I keep repeating it, so I apologize, is just the reduction in that street frontage and then moving to the subdivision after that. And again, the reason why you have to do the conditional use first is that if he doesn't get the relief for the street frontage, then there's no way for him to move forward with the subdivision that he, you know, as is right now. So that's just my last piece. Thank you.
All right, Tom, you're off the hook. All right, buddy.
Steve, can I ask a question that maybe you can explain just so that
You're
I'm
good,
sure
Tom.
that I understand? Can you just explain what you were saying about the fact that the minimum is 175, but there's a provision that allows it to be reduced to 160
150.
or
150.
Okay,
So-
yeah, can you explain what that is and what triggers that?
Well, what triggers that is the request by the applicant to the board as a conditional use hearing that you're having. So it is not asking for a variance, like saying we want to make the lot smaller. The lot still is fitting the same size. It's basically saying in this setting, does it make sense for these two lots that would meet all the requirements of an R1 lot every other way, except for the fact that they don't have enough frontage? And based on where this is that okay? And that's the hearing that's before you in that way. And you, as the board, have the right to rule and say whether or not you agree to that, taking it down. You can take it as low as 150. I believe they're asking for 158.4 or something like that per lot. I hope that answers your question.
It does. So
It's in our code. It's in the code that allows for that.
All right, so next steps, we go to,
Right now, you'll decide on whether the conditional use.
so where are we at with that? That is 12.1, so we move to 13.1.
So no.
Right now.
You're still on 12.1,
12.1.
and then you're,
The associated ordinance is
15.1, so move down to 15.1. All right, so we'll move down to 15.1, considering approving the ordinance 2026-02-22-24 Boot Road. I have a motion.
So are we making a motion to approve the requested conditional use relief?
That's what you're deciding right now.
if you're saying approving the ordinance, yes.
Yes.
Yeah. Okay. I'll make the motion.
I'll second. All in favor? Aye. All opposed?
Aye.
Opposed.
3-2, motion passes. We'll go up to 13.1 now.
Yes.
Yes.
Consider the application for subdivision approval 2020-24 subdivision application. I'll read this, correct?
Well, you might want to listen to the subdivision
Okay.
application. So Vince will give you
So we're back to,
an overview of what the subdivision is and the waivers that they're requesting before you do that.
Just by way of an overview, not all subdivisions are land development, or rather, not all land developments are actually, all land developments are subdivisions, but not all subdivisions are land development. I know that sounds goofy, but that's the definition under the MPC. What we're doing here, and what we're asking to be done, is that we have subdivision approval without a land development component, which is actually the design for the footprint of the house and all that stuff. Now, normally with the development, if it's a complex commercial development or something like that, you're going to have both proceeding in at the same time. If it's subdivided, you also get all the structures and whatever. Here we're talking about basically 2 building lots for houses, and you're primarily concerned about building envelopes, setbacks, impervious coverage, driveway locations. None of these things were Robert really is prepared to go forward with, other than to get the subdivided lots. And then the agreement or the stipulation would be that at any time you come back for a building permit or development, you have to satisfy all the information that is required, that would have been required if you had done it at the same time with the subdivision. And that is not a difficult thing to achieve in a, subdivision of this nature. If it was more involved or more complicated, perhaps there would be a good argument. But in this instance, we have to come back, whether it's by permit or if you want to couch it in a full land development application.
Can I just interrupt you for a second? Is there a way you could check to see if your microphone's on? Because I can't hear you.
All right, if I have to, I'll swallow it. As I said, what we had told the planning commission is we would like to go for subdivision, have the lots, because you never know what ordinances change or how and when Robert wants to proceed forward. But it's done with the stipulation that at the time that before any building permit is issued, we would have to comply with any requirement, whether it's that the engineer could have insisted on at this time, whether it's steep slopes, we would do it at that time. But at this time, we don't have a land development proposal because we don't know what size houses. We don't know, we know we have to stay within the setbacks and the building envelope, but we don't know where the property owner wants to locate, the driveway, what type of driveway. But regardless, we would have to comply with the impervious ground coverage, and we would have to, put forth stormwater management facilities, which we can't do now because we don't know the scope of the development.
So, Mr. Mancini, if I can just interrupt you, and maybe I'm missing something here, but I'm confused at why you're explaining all this when all you're looking for right now is a subdivision. You don't need to have, and correct me if I'm wrong here, you don't need to have an associated development plan with your subdivision. You can subdivide and not have that at the same time. So are you just, okay, sorry, I didn't know if I was missing a point there, if you were just, so are you just educating the board on the fact that there is no land development plan and all you're seeking for right now is to subdivide the property, correct?
I think what it's trying to do is explain to everybody in the room that this is only a subdivision. When they come back or whatever they decide, what size house, what shape, what form, they all got to come back for preliminary approval and final approval. And that's all he's trying to say is he's not going away tonight with everything already approved. He's got to come back at least once, possibly twice.
Again,
So I just want to be clear. This is a subdivision. This is a simple subdivision that will be 2 lots at the end of the day. If these 2 lots existed today, just as what you potentially would approve tonight, and somebody came in to build a house and they stuck it within the buildable lot, this buildable lot area, they did not exceed the amount of impervious coverage. Everything was according to our zoning code. I do not believe they would have to come back before you. And so I just want to be very clear.
Of him fitting everything in a smaller lot with and getting all the correct drainage and everything is going to be checked by the engineer are going to, it is possible, but it's probably not probable.
I guess my point is, I want to be clear to the board and to the public. If they build a house that meets all the requirements of our zoning and they submit that permit to the township, there would be nothing forcing them to come back to the board.
No, except our stipulation and condition that we comply with all the requirements that the engineer could have required us to comply with at the very outset. And we're amenable to that.
Okay.
Because.
So are you saying you're going to comply to come back to the board and go through land development?
If he gets one waiver, he has to come back to the board. Eric can't grant a waiver. We can only
Yeah.
grant the waivers. He gets one waiver, he's got to come back.
We don't get we don't get a waiver, we do have to come back.
That's correct. I understand that, but I guess my point is if you met all of the township's requirements, and I'm just making sure that it's being, here's what I'm trying to keep from happening. If the property either is developed by Mr. Staniloff, or if it is sold and developed by somebody else, and they meet all the township requirements and meet all the engineering requirements, and it doesn't come back before this board, I don't want the public thinking in any way that the board tried to do something that it wasn't supposed to do, or that the applicant did. I just wanted to be very clear that if these two lots existed today, before this part of what you're doing, if the two lots existed today, just like any other infill lot in town, and you meet all the requirements of what is there, you do not have to come back to the board for land development just to
You
build
are
a house. And that's what I just want to be clear on.
Okay, you are correct, except, again, we're willing to take a condition that not only, for example, if somebody comes in for a building permit, they may not have to do a scale topographic study on their whole lot to just show where they're going to put it. It's not touching it. We have agreed that where there are separate articles in your, in your code ordinance, your subdivision land development, for example, incorporates stormwater management studies. It incorporates.
Mr. Mancini, your colleague is dying to speak right now.
Yeah.
He's dying to speak.
Ooh. Go ahead.
Steve, to answer your question, unless required, we probably would not voluntarily appear before the board again. But it is the intent of this application to subdivide the property and propose no physical improvement to the site tonight. But to answer your question, yes, if required, we would happily appear before the board again. If not, we would submit a residential lot plan. If and when that time came, it is not tonight. It is not something that I am aware of. I can say that truthfully. So this is just a submission of an application to create two lots for my client's business planning, whatever that may be.
If the zoning board so requires it, we'll do that. We'll submit a.
Thank you.
So let me ask you this, question, Mr. Mancini. How do we have the authority to apply a condition for a subdivision? I mean, let's go through the exercise. I don't think that there's a legal avenue for the Board of Supervisors to impose a condition at a subdivision level that would require you to come back.
I think if conditions are acceptable to the applicant, whatever conditions are imposed are enforced.
Yeah, but let's say, like, listen, we all know you and respect you, and we have respect for the applicant. But let's say this changes hands and it's a different lawyer and it's a different property owner. If it's not a legally enforceable and legally binding condition, then there is no, because again, I don't see how we can do that at a subdivision level. I also am of the mindset too, though, to play devil's advocate, that I don't think we should be treating these parcels any differently than any other parcel in the township. And if they are building something compliant to the code, then I don't see why we would single them out. Yeah, I'm going to lose you. I'm sorry. I'm about to go through a tunnel, but you can start responding and I'll pick up how I can.
We need to have a conversation with your ownership and the residents. And hopefully, if we have an intelligent, calm conversation, we can resolve some of the concerns. We're not going to resolve all these concerns about the traffic and about the driveways and all, but hopefully about some of the maintenance things and some of the other things that they're concerned about. We can work with so the applicant and the residents.
So to dovetail on Supervisor Russo and Supervisor Terry, again, it's just the subdivision tonight. Anything moving forward.
Okay, like I said,
We
we will.
discussions will and should happen. And again, like Mr. Nease said, does fall under the law. Great, but we highly recommend if they do come within all our zoning, things like that, that we will make sure that conversations still happen with the neighbors.
I think after what I heard tonight with everybody here in the room. And we gave him the approval to subdivide or to the, for the width. That he has to go have a conversation and then come back again to get it subdivided. That way, at least they had the opportunity to talk to the owner. Everybody can raise their concerns. Hopefully we can solve some of these concerns. We're not gonna solve them all, but at least then they have an opportunity, because if there's no mechanism for them to have that conversation, I think it's just gonna get more frustrating for everybody.
My problem with a lot of the conversation tonight is it's not about these two subdivisions. It's about the whole property, the whole thing on Westchester Pike. Traffic, we can't.
Well, no, I'm not talking about any of those issues. I'm talking about open a conversation up so the residents can have a conversation with him or his representatives. They can, then, once they have the conversation, we can come back at the next meeting and finalize this, the next step. I don't think it's fair that if he walks away tonight with this approval and he goes and sells these to John Smith or Jim Jones, and they're not as nice or as respectful or whatever you want to say about it, and they just do whatever they want that meets the code, then we have not helped the residents. At least we have a conversation to try to mitigate some of the concerns. I think that's the best we're going to do here.
But
We're
I
never
think
gonna
we
mitigate all
still,
these concerns.
I still think though, like, I don't want us to lose sight of the fact that even if a project is not come up before the zoning hearing board or the board of supervisors, our third-party professionals are still going through the ordinances and making sure that any application is indeed complying with the ordinances. And it's not our role to usurp the ordinances if someone's complying with them. So the only big issue I have with this is, like, I get what Mr. Mancini is trying to accomplish. I don't see how it's legally enforceable. But again, at the other end of the spectrum, I have no interest in treating these parcels any differently than any other parcels in the township. And again, just because someone's not coming to us for a waiver or land development, they're still complying with what the ordinances are under the township.
Well, Leonard, I don't think we're arguing about whether we should gratuitously require them to come in after this is approved anymore. I think we're talking about whether we hold off approving the subdivision until they have a conversation with the neighbors.
Are you asking?
We are asking for 3 waivers as part of the subdivision plan.
Yeah, but again.
Well, now we're Plainville. We're at the subdivision. Yeah, and we're gonna grant those waivers to you.
Yes, I believe so.
What are the waivers?
What are the waivers?
The
Jake?
waivers that we are requesting are to combine preliminary and final approval so that it can be done at one time, which is typical to applications of minor improvements such as this.
That's the subdivision.
Subdivisions, excuse me. We are requesting a waiver from the site design and layout of the plan, specifically as it relates to showing or depicting existing conditions within 300 feet of the subject property. Again, because it is irrelevant to the actual subdivision of the property, we don't have existing conditions for the neighboring properties shown on the application exhibit. And then thirdly, we are requesting to omit from the plan presentation the depiction of very steep slopes and steep slopes which occur within the right of way, again, because no improvements are proposed.
Eric, for the existing conditions, sir, for the existing conditions waiver, could they just do a aerial? Would that satisfy our ordinance? Or do we have specific requirements in the ordinance of showing water lines, fire hydrants, etc.?
I believe so. You guys did a survey of the property, correct?
A survey of just the property, yes.
Right, which consists of, you did the meets, bounds, boundaries, topography, but not into greater detail of items that will be relevant to constructing on the property.
Not beyond our property frontage, correct. So just what is within our property.
Let me just, you are seeking the waiver for
A lot of times you can satisfy it by just doing an aerial. Unless we're looking for specific, water lines and gas lines.
Conversation?
I think we should table it for one meeting. I mean, it's not gonna change the overall vote at the end, but I think you need to have a conversation. Client and residents. I mean,
Yeah.
you guys are neighbors. I mean, come on. I mean, they're unhappy. Some of these things I think they're unhappy about, you can fix. Some of them you're not gonna fix. Be realistic. I drive on Blue Road too, and I see how people go, and it's not just people in fast cars, it's people in every car. And you can't walk on. There's no sidewalk, it's not safe, it's too hilly, it's too curvy. It's hard even when you come out around the corner, or even when you're coming in towards Goshen, the bushes or the trees are.
Mike, have your microphone on, please.
We're not gonna fit these items and fix them all, but we can hopefully fix some to work with them, be neighborly. And I think that's my suggestion. I think that's the suggestion. Two other members are sitting up here with me tonight. And I think let's just try to be good neighbors.
Can I make a suggestion? Can we please address the frontage this evening at least, and we'll come back.
You got it.
All right. Okay. We understand the board's concern.
Well, Mr.
I'll make
Nancy
some
wants to.
recommendations to, to the client.
Ask a quick question.
Not right now.
We're trying to help you and we gotta go like, we're trying to get a meeting with you and the owner of the property.
Not
We
right
really
now.
can't have some other conversations.
Not right now. This is a board discussion, not public comment. Thank you.
We're amenable.
If you want to make a motion to table, or the applicant wants to withdraw for tonight, either one of those two is an option.
No, continue it. He doesn't want to, don't withdraw it. Let's just take, we'll just make a motion. Let's make a motion to table it.
All in favor?
What, 1 second, real quick. Do we need an extension? I don't know.
I believe we.
I think we will. Would you give us an
I think I
extension?
had given, well, if you need whatever you need, I'll give it to you.
When's the next meeting?
The next meeting is
August.
July, July
13th, I think.
13th. So, yeah, can you have met, that's like 3 weeks. Can your client have met with is that enough time for you to do what is being asked?
Sure. Well, I'm not sure what the client's schedule and what,
So
he's.
if you will give us at least an extension to the 13th tonight, if you want to extend it beyond that, then that'll be up to you to provide that, please.
Extend to what?
July 13th.
July 13th.
And just maybe to help us, okay.
Take it to the end of July or something.
You want
Well, we
to,
only have one meeting in July.
Okay.
So.
you want to take it to the 10th of August then?
I'm probably overstepping my bounds right now without.
Well, give us the 13th with,
That's why I'm saying, give me the 13th, and if you and the client decide,
Take a minute to make a phone call, please.
I'm gonna defer that to
Oh,
the,
you've got until the
the 13th. Yeah,
yeah.
you'll get 13th.
If you want to take beyond that, then you just let us know.
Okay, we'll do.
And then just to the waivers, maybe just facilitate the next meeting if to see where you are on that. 3 waivers they're seeking is the combination of the preliminary final plan, which for honestly, for a subdivision is a pretty typical one. Just take that for what you will. The second one, as they said, it has to do with facilities that are outside within 300 feet, which may or may not be relevant when you're not actually building anything. And the third one, which maybe if you want to give some direction on what your thought is on that, basically they've done a survey, they have topography, they have the property lines. We know there are some steep slopes on there. They have not specifically delineated them on the plan, and correct me if I'm wrong, but you're seeking just to not have done that on the plan. I guess the direction what's your feeling towards that? Do you want them, are you okay with that? Would you ask them to provide some more information to facilitate?
5%?
Are you saying?
What
What is it?
We'll provide that documentation.
Yeah, that's.
You're asking for.
And that's why if it helps the next meeting, then that's the direction maybe giving to you.
Yeah, so can I just submit that directly to you guys?
Yeah, I can submit that, yes.
Okay, we'll work on that and have that submitted and ready for our next meeting.
We can do, yeah, the only thing we can't do is give a design of a house.
We don't want
We
that.
don't want
We don't
that.
want that.
Mr. Mancini, all I'm asking is, there's a lot of frustration with these
Yeah, I
folks.
understand.
You guys are all I mean, not you, but he's neighbors with these people.
Stop, stop.
Let's just try to
Let
be neighborly
them
and
talk,
hopefully
please, then you'll
solve
have
somebody's
public
problem.
comment at the end. So there's a motion on the floor to table this till next meeting.
Second,
I know. Okay.
oh,
3 seconds. All in favor?
aye.
All opposed?
Aye.
Motion carries. Moving on to the next thing. We are moving on to, so you guys are done with the table, we're tabling at the next meeting, so you guys are dismissed. Thank you for coming.
Thank you.
Do it next time. The next thing is 13.2, considering approval to the stormwater modifications to the approved land development plan for the Veterans Hall meeting. This should be pretty easy. This is wonderful. The Veterans Hall, this is great. Welcome.
Good evening. My name is Rick Stratton. I'm with Chester Valley Engineers, representing the applicant and the landowner, which is the formal name for that is Joy for Newtown Village LP. I'll give you a brief history here. We had an approved land development plan, which was approved right around June of 2025 to construct the Veterans Meeting Hall and some associated site parking. There was stormwater management proposed with that. There was landscaping proposed with that plan. And the thinking at that time was to propose stormwater management for not just the meeting hall and its parking, but other future development. While they're working in this area, while the site was under construction, the thinking at that time is it makes good economic sense to design and construct the stormwater while we're in here for the meeting hall to handle some other future development. We didn't know exactly what that development was, but it was possibly an office building, possibly additional parking on the site. And so that's how the plan was approved. That's how we designed it. It was more stormwater management than the meeting hall required. And it was approved by the township. And we also got NIPD's approval from the Chester County Conservation District and DEP. So that happened June 2025. Fast forward to about November of 2025, the thinking kind of shifted and changed. And there was some uncertainty with future development. And the owner said, we're not sure exactly what's going in here. And this is a pretty large undertaking, the stormwater design. So what if we only propose stormwater to treat just the veterans, just what we're building now? And so rather than volunteer stormwater more than they needed, let's only build what's required by the code and by DEP. And so we looked at it, we came up with a refined design, we reduced the size of the underground stormwater beds. We submitted a plan to the township. We also submitted a plan to the Conservation District, and both the township and the Conservation District reviewed that. They gave us some comments. We resubmitted, and then both the township engineer and the Conservation District approved the revision. But one of the conditions was they asked that we come to you and formally request it at a public meeting. So tonight we're just asking for the Board of Supervisors to formally approve and recognize this reduced stormwater management plan. And I can get into some specifics if you want, but that's basically what we're asking.
Eric, are you okay with it?
I am. The only real substantive difference is they have an underground basin, and then in the rear behind basically where the parking is, there's a small above ground basin. There really is no substantive change to the memorial itself.
Okay, so it's gonna cover what they're gonna be building in the next however many months is gonna be fully covered, meet the requirements. You approved it, the county's approved it.
Correct. Yes.
Perfect, thank you.
So I have plans if you want to look at them.
No, I don't think we need to talk about this.
Understood.
I think we need to make a motion.
I'll second it.
All in favor?
Aye.
All opposed?
Thank you.
Motion carries.
Thank you.
Thank you
Oh,
so
I had
much.
I had like 15 questions for Mr. Stratton too. He's lucky I'm on the phone.
I'm out the door,
I'm
Leonard.
muting his mic as the this meeting tonight.
Thank you.
Welcome, thank you. So to go back, I have to read the conditional use for that pass, correct?
15.1.
15.1.
Yep.
Oh, I thought that was right.
I didn't read it.
Oh, yes.
Because.
For the record. we
For the
can
record,
cover
so I'm
that.
gonna read that for the record. So there's the order of 15.1. And now the 22nd day of June, 2026, upon the application of Rock Hill Real Estate LLC for the conditional use approval to subdivide one lot and two lot with less than the required 175 street frontage per lot per township code section 17229B 1B to allow street frontage of 157 feet and 154.65 feet respectively. And upon a majority in favor of the vote of application at June 22nd, 2026, Board of Supervisors meeting. Conditional use approval is hereby granted, subject to permitting requirements as well as compliance with all relevant codes, ordinance, statutes, and compliance with the corresponding land development approval. Granted this day, 22nd day of June 2026 by the Board of Supervisors of Newtown Township. Does that satisfy that requirement?
I believe so.
Yes.
You should probably also do the resolution for the stormwater management piece that you just did.
Don't have that.
You don't have that,
We-
okay.
They just have to.
We just have to.
Okay, we'll
Yes.
do a resolution that will follow. I'm
Yep.
sorry, I knew that. That's
Okay.
my,
So I'll move down to 14.2. So we did vote on that
Yes.
resolution, so we're good with that, right?
Yep.
So just
you,
have to
that
approve
you,
that.
just for the record, so everybody knows
Sure.
what you voted 3-2
3-2.
Yes.
That's for
for the ordinance.
Rock
oh,
Hill, yes.
For the
veterans, we're 5-0.
For veterans, you're 5-0.
Yeah,
Yeah.
all right. So we did 15.1, now I'm on 15.2, ordinances. Consider authorizing the advertisement of sending of the data center ordinance of both township and county planning commissions. Before we vote, Mr. Nease, can you expand on that?
Yeah, so we're kind of keeping up with the other municipalities around us that are putting data ordinances in. The real purpose of doing so is to kind of have best practices and make sure that in the process that we're moving the township forward in a way that we think best represents the values of the township.
And there's been no applicants or anything.
There
like
have
that,
been no
correct?
applicants. We're not doing this in response to an application. We're doing this proactively.
Thank you, Mr. Neese. Go ahead. Motion.
I'll make a motion.
I'll second it.
First from Supervisor Altieri, second from Supervisor Grasso. Any board comment?
Yeah, I just want to piggyback off of what Steve said because I think this is extremely important. There are no applications or discussions with regards to this. And Steve said best practices. What this does is it protects the township the best way that we can in the event that one of these applications were to ever be filed in the township. So, you know, what right now we are vulnerable and open. What this will do will put strong parameters on any potential data center coming in here. The reality of the situation is that it's very unlikely one would be coming into Newtown Township, but I think it's irresponsible for us not to move forward with putting these protections in place to protect our zoning ordinance and more importantly, our community.
And our neighboring townships have done this or are in the process of doing this also.
Yeah, a lot of them have. I mean,
Yep.
Concord's going through it right now.
Marple.
You know, there's
Radnor,
Marple
yep.
just
So all in favor? Aye.
Aye.
All opposed? Motion passes. 15.3, consider authorizing the advertisement of sending the rooster ordinance to both the township and county planning commissions. Mr. Neese,
I
you
actually
want to
think
expand
we're-
or is it just self-explanatory?
No, actually, it's more of a domestic animal
Right.
ordinance. It's a little bit broader than just a rooster ordinance.
Yes,
We should have probably listed it as a domestic
domestic
Animal.
animals.
ordinance. The focus is on looking at domestic pets, you know, in controlling, I shouldn't say controlling, but in looking at the number on a property just to make sure that it doesn't become overburdensome for the neighbors. Also, it will address things like obviously chickens and things like that, but there's also some clarification in having a horse and those kind of things. And so if that ordinance will be publicized on the township website for people to review, just like the other one.
Thank you, Mr. Neese. Do I have a motion?
So moved.
First by Supervisor Grasso, second by Supervisor Russo. Any board comment?
My understanding, just want to make sure it's clear though, is that we're advertising this to send it to planning commission so that they can give us their input, not saying that we're in favor of how it's written right now. Is that accurate?
Well, we're sending it over to the planning commission, both the townships and the county's planning commission. That's what goes, and then it'll be advertised once they've reviewed it, and then it'll come back to you for approval.
Any other board comment?
But the important thing to remember here is that any changes made after this day, we would have to probably go through that process again.
Leonard, I thought it was any major changes.
Yeah,
We
so
used-
anything, so Rich sent a draft out. I believe one supervisor did reach out with regards to edits. Those are going to be changed before they get sent to the county planning commission and the township planning commission. And then any changes, like if they say, hey, we're recommending A, B, and C, or even if they don't recommend anything and we decide to make some sort of changes, there's a potential that we have to go through the process again, which is sending it back up to them.
Any
Well,
other
actually,
board
no,
comment?
I might stand corrected because we're not voting to advertise it right now. Correct, Stephen? We're just sending it to, we're just voting to send it to them.
You are voting to advertise, but you'll be advertising after it goes there. And so once it goes to the planning commissions, both planning commissions, if there's any substance changes, they would be made, and then it would be advertised for the required period of time before you voted on it.
So put another way, if anybody has any changes, I would get them to the solicitor before they go to the county and the township planning commission, so that when we advertise, we're not making changes on the fly. Because once we advertise, that will trigger it to go through that process again, or at least a re-advertising of it, if it's a major change.
Any other board comment? All those in favor?
Aye.
All opposed? Motion carries. 16, public comment. Any public comment has 3 minutes for public comment. Please your name and address for the record.
Hi, my name's Howard Walker. I live at 102 Boot Road. I just want to make a comment. I think we're kind of losing sight of the issue. I'm not going to meet with the Porsche dealer because I've met with him in the past and I have no desire to talk with him again. But I think the precedent being set is any other lot that's over 3 acres can now come in front of the Board of Supervisors and be split, because there's no reason why it can't if we're going to approve this one, right? And I know it's not something we're discussing tonight, but I'm just worried about that precedent. There's 5 other lots on our street right now that are over the size of this lot that's being proposed to be split. So what's going to stop anybody else from doing the same thing? I think that's what we should be focused on, not how bad he's acting or how bad he's acted in the past and continues to act. That's not what we're talking about. We're talking about the precedent being set by the Board of Supervisors that any lot over 3.2 acres is able to be split into 2 and built on. That's the biggest concern I think that everybody in our neighborhood's concerned about. Thanks.
Thank you for your comment. Any other comments? Name, address for the record.
My name's Karen McDonald, and again, I live at 45 Boot Road. I just wanted to speak to the sense of decorum here tonight. We are not legal people. We appreciate, and I want to extend that personally, the job that you do. But I think that what you sense is a lot of frustration, us not having gotten this information until 5:30 Friday evening and trying to understand it and disseminate it to our neighbors, many of whom are septuagenarians and octogenarians and can't come out in the evenings because it's so late. And that's to be understood. So we're trying to, do the job. I just feel that it's unfortunate. I know many people, myself included, I'm a retired school teacher. We have frustrations at the end of the day, but I don't appreciate being cut off without having been told what my parameters are, nor to be shouted at. I just don't think that that accomplishes anything, nor does it breed a good faith among us. And we're all here, I think, for the community. And at the end of the day, again, the gentleman that I referred to who was so eloquent and so helpful to us in the past, he said, what we have to understand is that while we want to grow as a community and incorporate certain entities into our neighborhoods, certainly people have a right, to prosperity and their American dream, and on the commercial lots, that's wonderful. But we have to ask ourselves, what benefit is all of this? What Mr. Walker just said and the other folks just said, what benefit is this to the people of Boot Road? I mean, because we are that community. And so again, I would just ask, if we broke decorum, it's because we don't do this job. We don't come here regularly. And that was not intentional, but I think just in the spirit of our getting together, and I am hoping we don't have to do this again or often. I would just ask that we could have that same mutual respect. Thank you.
Thank you for your comment. Name and address, please.
Joe McDonald, 45 Boot Road. I feel like there's been a lot of disagreement even among the board, and that's translated to the direction that was given to us. I tried to raise some questions about the three waivers that were identified in the letter, and I was told that that was not part of the conversation tonight. I think ultimately, we approved at least one of them. I think there was some discussion among the board on what we were talking about, conditional use versus the waivers versus zoning I don't know if I still understand, exactly what we approved tonight, other than the frontage variance, but there were three waivers that I was attempting to address, and and I had some comments, and I'm still not sure, is there another step, or is there not another step? But I think that there was not clear direction and a clear even understanding among the board, because I couldn't follow it. And I think that has led to my frustration. I don't leave here feeling like I understand exactly what was done here tonight, but maybe that'll get resolved down the road.
Mr. McDonald, the code allows us to go down 150 feet. So even if we denied him, he's gonna go to court, common pleas, they're gonna give him approval. So all we're doing is delaying it. It is better for us to have a meeting with him and you to try to resolve some of the grievances. And the waivers are de minimis, okay? None of those waivers are gonna hold him up from building those houses. And any of your neighbors on that street that have bigger properties, you included, are able to subdivide your property. And if you want to get 152, frontage on your house or your property, when you subdivide it, you're allowed to do that. That's the code allows that. There's nothing we can do to prevent him from asking for those waivers. And if we don't give them to him, he's gonna go to court and get them. Because the court in this county is very adverse to controlling people's property. And so we're trying to get the best situation for you by having you have a meeting with him to try to clean up some of the issues. Speeding down the road, the fact that you don't want another driveway on the road, stuff like that, we can't control that. We're trying to do the best we can for you.
No, but if I can respond, so the one waiver was about the preliminary and final use all in one package. Why would
Because the municipality's planning code, and I don't mean to cut you off, but since I was the one who you're referencing, I do think it's important to address this. The municipality's planning code states that if an applicant receives preliminary approval and there's no substantive changes, they have an automatic right to final approval within 5 years. So you can get a preliminary approval and sit on it for 5 years. As long as you make no changes to it, you're guaranteed your final approval when you go through the process. So instead of eating up the resources of the township, what happens is it's commonplace across Pennsylvania that you submit a preliminary final land development plan. There will be additional conditions that are part of that would require an NPDS permit, an erosion and soil sediment control, conservation district, so on and so forth. That would be all post-approval conditions. But preliminary final is very, very, very common. And the point that I was making, Mr. McDonald, is that when you first got up, we were talking about conditional use. The conditional use hearing was only the objective criteria that the applicant had to achieve on the lot frontage. The board voted 3-2 on that. The next phase would have been the subdivision, which would have been where the waivers came into play. So I was saying that the questions that you were going to raise with regards to your waiver questions were not related to the conditional use, and they should have just waited until we got to the subdivision aspect of that application. But to the other point, that you're saying, this is confusing, and I said this in the beginning. People don't talk like this. Normal people who have lives don't talk about conforming lots and and front yards and all this other stuff. So I will say this to everybody in that room tonight, as I've done since I've been on this board. My email address is on the township website. I do this day in and day out as an actual profession. I will sit down with anyone over the phone, a cup of coffee, and I will explain to you the legal process. I will not get into the application with you, but I can speak about the legal process and the nomenclature to help you all in an attempt to get you to better understand, what this process is, because it is confusing. The law only requires that we post our agenda 24 hours in advance. We do it 36 hours in advance. So I know that's frustrating as well. And then to the last point about the lot sizes, there is no precedential decisions being made here, but anyone who conforms to the lot sizes can subdivide their property, whether it's on Boot Road or anywhere else in the township.
I appreciate that. And the only other point I was going to make in that letter that I read, again, was that the applicant was suggesting that there were no plans at that point when they submitted those waivers for these lots. And clearly there is a lot of plans. And, again, and the note in numerous times identified the request for the waivers with no project plans for the lots. So, again, the information may have been outdated, but I just wanted a chance to identify that. But again, I've learned a lot tonight.
Thank you for your comment.
If you send me an email, I'll follow up with you in person.
Thank you. We really.
Any other public comment? Name and address. Please use the microphone.
Helen Kane, 102 Boot Road. I just wanted to thank you all for listening to us. I apologize for my probably anger and outbursts. It's been so frustrating with Porsche. I think back to when 18 years ago we moved to Boot Road this week. And I often think to myself, damn, we should have moved to Gradyville. This Robert is just a nightmare, nasty as the day is long, lies.
All right, let's not get into character assassinations.
Okay.
We gotta be careful what we say.
Personal experience that I've had with him over the past decade. And I think a lot of us probably have a level of PTSD when it comes to Porsche and Robert, that immediately when I saw the little sign and it was turned sideways on his home, and I'm using air quotes, where there's a foundation poured, there was a tiny little sign, and I kept passing it and thinking I better look at it. I pulled over dangerously, walking on Boot Road, and took a picture. And that's one of the ways we knew about the meeting tonight. So it's always smoke and mirrors with this organization. So I hope you guys, you probably hear it in my voice, you probably hear it from all of us. The minute he wants to do something, the fear goes up and the defense kicks in, because we know we give him a little bit, he's going to keep taking big chunks. So again, appreciate your help tonight, and thank you for listening.
Any other public comment?
Hi, Suzanne McCutcheon, 149 Ashley Road. It was very heartening to hear how you guys all stood up for the residents that were here. As a member of the St. Albans neighborhood, I feel that we have no one to back us up on our concerns about El Car Wash at the Rite Aid. Their lawyer threatened lawsuits and if denied, and said that they will win and will build as originally planned with no concessions. The zoning board now has 45 days from June 18th to come to a decision. Why are the concerns and the requests left up to the lay people in the neighborhood? We are not experts nor lawyers or teachers and various other things. Why do we have no traffic experts of our own?
They will use the current exit onto St. Albans Circle, which has special circulation circumstances that the ITE data may not be able to account for. How can we get assistance on the traffic, or what concessions to ask for? This affects everyone that goes through the circles, accesses the businesses on the circle, as well as the home values for those people on roads. The strategic plan for our township has Directive 1, ease traffic congestion. 97% of the respondents to the strategic plan questionnaire strongly agreed that easing traffic congestion was an issue for the community. This was the strongest response to any of the issues facing our community. Directive 3 encouraged smart growth and thoughtful redevelopment. There was focus on wanting communal spaces and places to connect to the town center and redeveloping the old town center of St. Albans Circle. Section 3.6, and that said uniformly enforce the zoning, subdivision, and land development ordinances. We have a lot of frustration. We have a lot of people here at the zoning meeting on Thursday. Wish we could have more. If things don't go well, who's going to pay for it when all the traffic gets all stopped up? It's going to be us. Thank you for your time.
Favorite comment, public comment. Seeing none, any board comment?
I have.
Yeah, the only thing sorry, Cheryl. I mean
No.
Supervisor Grasso.
Oh, go ahead, Supervisor Altieri. I'll go after you.
No, you're good. You're good. Go ahead.
Okay. I was just going to say I can speak for me, but I do appreciate the public comment. I think part of our role here is to listen to the residents and do what we can to make sure that processes are fair, balanced, and that we take into account the needs of the community. I also just wanted to make a comment on the police report. I did enjoy reading Mr. Braverman's class letters to all of our police officers. That was really heartening to see all of the nice letters that the kids wrote to all of our police officers. For the Public Works report, just a reminder to the residents that when you drop off branches and tree limbs to the Public Works area that they allow for April to September, please only put in branches. We get weeds, vines, leaves, and other containers, and it is very difficult to go through the chipper. Finally, I did have a question about the sinkhole on French Road that was referenced. I know George is off Sharretts, so I will follow up with him, but I just saw that when I was reading through, and I wanted to see if there was any further concerns about that. But that's all I have. Thank you.
Any other public board comment?
Yeah, I just have one comment. Or maybe two. The first one is with regards to the last public comment that was made. I'm not going to talk specifically about El Car Wash because, as I have publicly stated, I have a conflict. Oh, sorry. I have a conflict there. But the board did vote at a public meeting to formally oppose that application. Our solicitor has been there for 6 months, cross-examining witnesses. So the thought that nobody's fighting for them from a township perspective is just not accurate. And I think that's important to just make sure that that is clearly noted. And that's all that I have.
Can I piggyback on that? Because since I'm taking one of the leads on that, since you're recused from yourself, I've talked to many residents in that neighborhood weekly that have emailed the zoning board, sent them to me, whatever. So there's constant communication when someone does reach out with reasonable and a request that we are responding back appropriately and immediately. You had something else, Mr. Altieri?
No, that's it.
Sure.
That's it.
You good?
Yep.
Okay.
I'm fine. Thank you. Great meeting, Supervisor Sanfrancesco.
Thank you. Any more comment? Seeing none, adjourn. Thank you.
Great job tonight.